If a fire breaks out on the far side of a giant cargo ship, nowhere near your container, never touching it, you can still be sent a bill for hundreds of thousands of dollars. Refuse to pay, and the shipping line can legally lock your cargo in a warehouse and never give it back. This isn't a scam, it's a rule of maritime law roughly 2,700 years old, older than Rome, older than Christianity, still running quietly underneath almost every container ship on Earth right now. It has a name, general average. Most people who get hit by it have never heard the term until the bill arrives. In March 2021, the Ever Given wedged sideways across the Suez Canal. You've seen the memes. What most people never saw came after it was pulled free. Companies whose cargo was never damaged, never opened, delivered in perfect condition, started getting invoices for a share of the disaster. Not claims against the shipowner, bills addressed to them for a wreck they had nothing to do with. Here's the mechanism, and it is running on ships right now as you watch this. When a major accident happens, a grounding, a fire, a salvage operation, the shipowner can formally declare general average. That single declaration flips a legal switch. From that moment, every company with cargo on that ship, whether their box was destroyed or 3 decks away and untouched, becomes financially responsible for a slice of the total damage. Not the shipowner, them. A specialist called an average adjuster gets called in, one of the more obscure and lucrative jobs in the maritime world, and their entire task is to add up every dollar spent to save the ship and its cargo, salvage tug fees, extra fuel port costs, legal fees, sometimes a 9-figure ransom demand from a canal authority. Then they divide that total across every single cargo owner on board, in proportion to how much their goods are worth. Before any container gets released, every owner, or more realistically their insurer, has to sign a bond guaranteeing they will pay their calculated share. Until that paperwork clears, the cargo does not leave port. It doesn't matter if you're a massive importer or a small business that shipped 1 pallet of sneakers. You're locked in with everyone else on that hull. This is the actual reason marine cargo insurance is treated as close to mandatory for anyone shipping internationally, not to cover theft, not to cover a drop box. It exists specifically to cover this exposure, the possibility that your untouched cargo gets legally billed for someone else's emergency. Average adjusting firms, protection and indemnity insurers like the UKP and iClub, and Lloyd's underwriters form a quiet layer of the shipping economy that most importers never think about until the one time they suddenly need it. So where did a rule this aggressive come from, and why has nobody managed to kill it in 2,700 years? Go back to the Aegean roughly 800 years before the Common Era, long before insurance companies, before banks, before anything resembling modern contract law. A trading ship hits a storm and starts taking on too much weight. The captain has one option: throw cargo overboard to lighten the load and save the vessel. That sacrifice saves the ship, and it saves everyone else's cargo too. But the merchant whose specific crates got thrown into the sea loses everything, while the merchant standing next to him loses nothing, purely by chance. Traders around the island of Rhodes formalized a fixed: if cargo is deliberately sacrificed to save the shared voyage, the loss gets spread proportionally across everyone who benefited, including the owners whose goods were never touched. Rome absorbed the principle into its own law. Medieval Europe kept it running. It was formally codified as the York-Antwerp rules in 1890. And it has been updated as recently as 2016. It may be the oldest continuously operating piece of commercial law still in active use anywhere on the planet. That explains why the rule was invented. It does not explain how something built for a single wooden ship with a dozen merchants aboard still functions on a modern vessel, carrying cargo for 100 different companies spread across 40 countries. That part is pure modern finance, layered on top of an ancient idea. And the Ever Given case shows exactly how strained that layering gets. Days after the ship was refloated, its owner formally declared general average. Separately, the Suez Canal Authority filed its own claim against the vessel for roughly $900 million, reportedly built from a $300 million salvage bonus, plus another $300 million for alleged reputational damage to the canal itself, and used an Egyptian court order to keep the ship and its more than 18,000 containers seized in the Great Bitter Lake until it was paid. After months of negotiation, that specific figure was settled around $550 million. That was only the Canal Authority's claim. Separately, insurers and lawyers still had to untangle general average contributions across cargo interests, reportedly spanning up to 20,000 containers, with potentially 20 or more different owners sharing a single box. Maritime lawyers at the time called it a contender for the single most complicated general average claim ever filed. Ordinary businesses that had never heard of Rhodes or of General Average sat for months with no idea how much they owed for a ship they had simply booked space on. Notice who actually holds the leverage in this system. The average adjuster is not picked by the 200 cargo owners scattered across 40 countries. The adjuster is appointed by the shipowner, working from figures the shipowner's own team assembles. Cargo owners can dispute the numbers, but only after the fact, only through lawyers, and only while their goods sit locked in a warehouse racking up storage fees. For a large importer with an in-house legal team, that's an annoyance. For a small business that shipped one pallet through a freight forwarder, it can mean months of frozen inventory and a bill they have almost no practical way to challenge before it comes due. The Ever Given claim shows exactly how far that leverage can stretch. The Suez Canal Authority didn't just bill for the physical cost of freeing a grounded ship. Roughly half of its $900 million demand was built from an alleged reputational damage figure, a category with no fixed formula and no obvious ceiling, attached to a vessel the authority had physical control over inside Egyptian territorial waters. Maritime lawyers openly debated whether that number reflected real cost or simple leverage. A canal authority using the one moment it held a 20,000 container ship hostage to negotiate a figure far above what a salvage operation alone would justify. The final settlement, around $550 million, suggests the number was negotiable all along. Cargo owners further down the chain had no seat at that table. A shipping line based in Japan and an average adjuster working out of London settled the framework of the deal, while the businesses actually paying for it. A toy importer in Ohio, an electronics distributor in Rotterdam simply waited to find out what percentage they owed once. The paperwork finally reached them, sometimes more than a year after the ship had already sailed on to its next port. Here is the part almost nobody clocks. You don't opt into this. There is no checkbox, no warning, no separate contract you sign. The moment your cargo goes into a container and that container goes onto a vessel, you are automatically enrolled in a mutual risk pool with every other shipper on that hull, bound by a legal principle written down before the Colosseum existed. You find out you're a member the day something goes wrong. The 2016 update to the York-Antwerp rules wasn't cosmetic. One of its central goals was trimming, which costs ship owners could even claim after decades of complaints that the system had drifted toward padding legitimate salvage expenses with soft categories like the reputational damage line the Suez Canal Authority later leaned on. Insurers pushed for it. Cargo interests pushed for it. And it still didn't stop the Ever Given claim from becoming one of the most contested general average cases in modern shipping history, which tells you how much room for interpretation survives even inside a supposedly modernized rulebook. And the exposure is only getting bigger. When General Average was last meaningfully modernized, ships carried a few thousand containers. Today's largest vessels carry over 24,000. Every additional container is another company that can get pulled into a future bill it never saw coming, for a disaster it never caused on a ship it merely happened to book space on. Insurers and maritime law bodies have been pushing for simplified adjusting rules, digital claims processing, and minimum thresholds designed to keep the smallest claims out of this centuries-old machinery entirely, specifically because a manual months-long adjustment process makes less sense with every generation of bigger ship that gets built. Underneath the modern language of container shipping, freight rates, bills of lading, container leases, there is still a fragment of Bronze Age Mediterranean law quietly enforcing the exact same idea it enforced 2,700 years ago. Everyone whose goods share a hull shares the risk of that hull. It has outlasted empires and entire economic systems because the underlying math still works and because almost nobody outside the shipping industry knows it exists. So the next time you track a package crossing the ocean on a ship you've never heard of, you're not just paying for space inside a container. You are quietly enrolled in an agreement with every other cargo owner on that vessel, one that says if the ship ever runs into real trouble, you will all share the bill together, whether your box was ever touched or not. Nobody explains that to you at checkout. There's no line item for it on the shipping confirmation email. It just sits there in the background of global trade, a 2,700-year-old handshake between strangers who will never meet, waiting for the one voyage out of 1,000 where it actually gets invoked.